Hi, welcome to the LawCast. This is MJT Law. My name's Melanie Thorley. I'm the director, and this is Christy Santana, the associate. And today we're in our new space.
We're in a new space, new office.
Anybody wants to look in behind, you can see there's a few boxes floating around.
Yeah, there's still the packing process was, well, I was away for a lot of it.
Yes,
so
a lot of it. I like that.
For all of it.
Well, yeah, you were here to pack some boxes, but then not here to move at all.
No. I strategically took my annual leave well in advance.
Yes, brilliant.
To make sure I got away from that. But here we are in a new space.
New space.
And
I quite like it.
It's quite nice. It's a loft.
It is.
It's quite
It's
cool.
got like a mezzanine floor, which is quite fun, and we're all up on the top. So today we are in what we've created as the sort of podcasty video meeting room with plenty of boxes behind us.
So,
Yes.
But that brings us to what's on the agenda for today.
I've got a bunch of things I want to talk about, just kind of really briefly. There's a number of things that have happened. As you know, we've had the election and we've had a quick discussion over that. But the first thing I wanted to talk about was this. The Australian Labor Party has, as we know, they're going to be making some changes to the employment space, and one of the things they're going to be looking at is the modern slavery legislation.
Right.
Yeah,
Something that's been, it's a bit of I think, a bit of an elephant in the room
it's a really weird
in
one, isn't
employment in many ways.
Well, I mean, we talk about it. This is actually kind of interesting. So it's creating corporate responsibility. So for those who don't know, slavery exists in Australia. People's passports get taken off them when they arrive. They get placed into spaces where there are overcrowding, and they get to made to work very long hours for very little money.
Yeah, and there's usually it's done in a bit more of a sneaky way about the way their pay might work. For example, they might earn probably still under, but maybe $200, but 150 of them goes to accommodation, another 20 goes to food or something like that.
So with your passport taken away, there's very little hope you can go and find another job, because how do you get your passport back? You're living in places where it's very a normal environment. So people don't really put their hand up and say this is actually inappropriate, and the story gets controlled. So we know that's happening, but the Labor Party want to appoint an anti-slavery commissioner.
Right. Yeah, so what is that going to entail?
I really don't know. I mean, they're talking about it. It's new, got responsibilities, including publishing annual list of countries and regions and industries and products that are recognised as having a high risk of modern slavery. And what they're actually trying to do is bring in more corporate responsibility to how we are engaging with other countries and other organisations that are providing us goods and services who are involved in slavery themselves.
Right.
So this is all about corporate responsibility. And I find this really interesting, because for those of you who are as old as I am, we know that there used to be essentially a ledger or a line in the P&L to deal with bribes in certain countries.
Yep.
And that became a little bit unsavoury after a while, and that's kind of gone away, and we just don't talk about it anymore. Yeah. I'm sure bribes.
I'm sure it just gets accounted slightly differently.
I'm sure it just gets accounted for in a more creative way. Yeah. And this is about forced labour, and dealing with organisations that are dealing with the allocation of additional resources to support counter modern slavery, people smuggling, human trafficking, and it's aimed to just to not be what they say a tick in a box approach to modern slavery. So this is all very new. Again, we are we're still learning about all this.
These are all just
something
ambitions, but
something that's popped up.
did you get the feel as though it was outwardly focused or
Yeah,
inwardly
no,
focused?
mostly it says entities should be conscious of the potential upcoming changes to preemptively review their supply chains and identify potential high-risk suppliers in preparation for the potential introduction of more onerous obligations. So we're talking about a fundamental change in legislation, making the end user responsible, I guess, for this question of whether slavery's happened.
I mean, I don't mind it as a kind of policy. I think, generally modern slavery is probably a pretty abhorrent kind of thing that happens in certainly in Australia. What I would like to see from that though is a little bit more inwardly focused. I mean, certainly it's great that we're focusing
Let's try and stop slavery in Australia
first. Well, I mean, we can do both, actually, it should be said.
Yeah, they can do both.
Like, for example, I don't see any reason why that shouldn't be applied to the very large supermarket companies, and making sure that they treat their employees in a way that makes sense.
Well, that's true, and there's also, that this, and we know that there's been some issues with this, is the piece workers, the guys that were picking.
Yep.
Look, I'll be interested to see how this plays out. I would be very interested to have slavery wiped out, and it's something.
It happens far too often, and it does happen in Australia.
Yes, for those of you who think Australia is exempt from this sort of thing, it's happening actually on our back doors. We know of several matters that have happened in the Gold Coast, for instance, and we're in Brisbane, and that's 80 kilometres away.
Yeah,
so
exactly.
it is definitely happening out there. The next one I think is going to be a favourite of yours, Mr. D. Santana. This is about the professor who had an inappropriate relationship with a student while on an excursion at the university.
Yes.
Now we're talking about two adults engaging in sexual activity off campus where it was absolutely reciprocal.
Yes. In fact, from memory, the evidence kind of came out that the student was the one who initiated it.
Yeah, wholly consensual and instigated by the relevant student. Yeah.
So what are we talking about here? We're talking. We have a completely consensual relationship between
two adults,
one being a professor, one being a student of a university. They're in a way on a. It was like a retreat sort of thing.
Yeah.
The purpose of the retreat
academic retreat, which was held at a beachside location attended by both the academics and students. It says the attendees at the retreats included a student who was referred to as the relevant student at the proceedings, and she had been enrolled in a maths course, and which the applicant, the lecturer was the lecturer. At the time, the lecturer was in his mid-30s and the relevant student was in her 20s.
Right, and from memory, there was no question that all the marking...
sorry, I'm just going to move my chair around.
All the marking, all the assessment for that, I assume, semester had been done.
Look,
but I understand the retreat was kind of mid...
This is not about this is not about gaining favour, from what I can see. This is simply about whether or not it's appropriate for a lecturer to have a relationship with a student.
And there was a bit after that, wasn't there, as well? They kind of he breaks it off, and then she really pursues.
Yeah, there's a pursuing going on. It's all just very. But the interesting thing is, I don't think the student actually made much complaint.
It wasn't until she left, I believe, a couple of years later, where she. I'm not sure what brought it about, but she made the disclosure basically on the way out. And the university looked into it and terminated him.
They did terminate him, and there was a case.
Yes, he won initially.
He won, and they said there doesn't appear to be any inappropriate conduct here. Two adults having a consensual relationship is not unlawful. So there's kind of nothing happening here.
One of the best kind of lines that came from it was, I believe, the counsel for the applicant saying that to uphold the termination would be to subjugate women to the fact that they don't have their own free will.
So there was some arguments in court about what it meant for two adults to have a relationship, and to say that it was inappropriate for the man to have the relationship with the woman is to say the woman has no power to say no.
Yeah.
And they took that and they understood that. Then there was an appeal.
This has been I think, certainly one of the hotliest fought unfair dismissals through a Fair Work Commission.
There's no money in unfair dismissal people out there, so
he wants his reputation back, I suppose.
There's really, he's not going to recover legal fees. No one's getting paid here, except for the lawyers, of course.
There's 4 QCs involved.
It's just so much money floating around.
This might also be appealed, who knows.
So at the moment, it went to the full bench, the Fair Work Commission, and they overturned the reinstatement.
Yeah, so where was the differing of opinion?
Well, they said on appeal, the full bench found that the applicant's conduct, subsequent non-disclosure of it, is in fact the serious breach of employment obligations. And they stated that the applicant's duty at the retreat was to engage in education of students, so it was plainly incompatible with his duty to take the student down to the beach and become intimate with her. It says further it was held that the relationship was consensual, did not impact on the finding that there was a valid reason for the dismissal. So they took a different approach. The full bench decided that the reason for going to the retreat was not to fraternise, but in fact to, what was the word? To engage in education.
So it wasn't what he did, but it's what he failed to do.
Yeah, he failed to educate.
Yeah.
However,
when he was on the retreat, he was working, and he was principally an educator. I mean, he wasn't. If you were to put him as a one-word job.
We've talked about this a little bit about what is workplace conduct and what isn't workplace conduct. But I just wonder. They said it wasn't puritanical, blah blah blah. There were a couple of really interesting things that came out in the case, like he actually asked the other students whether it'd be okay if he got naked, right? I mean,
there was some strangeness about the way it was handled at the time.
He went down, it must have been warm, because there's no way I'd be hopping in water that was freezing, but he went down to this beachy area at night and just put his hand up and said, look, I'm gonna swim naked. Does anyone have an issue with this? And everyone went, no, do what you need to do, dude. So he went down, had a bit of a swim naked, she got in, and there was this kind of, I'm really interested that if his argument wasn't he wasn't at work, why would he be asking the students if it was okay to do something? Yeah. So there was kind of this failure, I think, to understand what his role was. I don't necessarily agree with this decision.
Go on.
Well, if we know this happens, if this was a different environment and it wasn't a university, let's say it was a recruiting firm. They do all sorts of things when it comes to prizes and awards, and they go to all these kind of spaces where, they go to like resort areas, they book out the entire resort and have big award weekends.
Yes.
There's all sorts of mischief going on, and it's subordinates, it's not subordinates, it's people, they're all piling into one room, they're not piling, it's all this stuff is going on. We know this because there's always something that comes out of it that's great for us.
January's a busy month.
Yeah, it's very good. And I don't think purely having sex with somebody that is in your peer group necessarily is unlawful. And if we use, and they did use this student/lecturer kind of hierarchy as one of the reasons, and we can do that in every situation.
Oh, there's always that similar power imbalance.
So are we going to prevent sexual activity in the workplace at these things? Are we going to expect that nobody's going to participate in any sexual activity because there's always going to be some type of hierarchy there. It might be a manager, it might be a 2IC, it could be anybody, and and are they all going to get fired? I mean, are we setting a really strange society where we can't have adult consensual activities?
Well, I tend to agree with your point of view here. I'm not sure how they came to the conclusion that the retreat was educational.
Also, it was the middle of the night. Everyone was in bed. What education was happening apart from the sexual activities?
It wasn't like they were on a field study. It wasn't, that they were...
Well, they weren't walking around counting penguin eggs at 2 o'clock in the morning.
No.
This is not what was happening. So look, I think it was a very... I think the university took a very hard-nosed approach, and I can see why they don't want people to be fraternising with students, etc. Lecturers fraternising with students in this way because we're all adults and it all just gets up to mischief. But what policy did he actually breach?
Well, what about the non-disclosure?
Not telling anyone. Well, why do we have to tell people about our sexual activity?
It's true. And arguably that will find yourself into your own trouble.
Yeah, why are you going to be expressing what happened last night?
Yeah, you might find yourself in trouble for some sexual harassment for that, especially if you're disclosing it about your peer.
Yeah,
Because
especially
it's not just you.
And if it's consensual and the person hasn't complained. Anyway, so maybe I've just been a bit... maybe I just don't understand the issues that are at play here, and I'll get 100,000 emails from someone. But I just don't see the problem with this. I would see the problem if it was during work hours, if they were still marking, if there was some sort of favouritism.
Yes.
I can see all of that. So I can see that there is, in some point, a policy that could be breached that has inappropriate conduct and there's favouritism or something's happened.
Yeah. This case represents almost the perfect storm where he's not falling foul of any of those things, which is very rare. Very, very rare. These kind of cases, you'd imagine there's always, if they're a subordinate, they might be a team, and there's going to be an issue about favouritism from the outset. If it's during work time, if they're flirting, for example, during work time, things like that, they might be doing sort of sexual harassment just in and around the place, which might make others uncomfortable, things like that. But that's none of this.
No, it's none of that. Anyway, so the poor sod got fired, didn't get fired, and now he's been fired.
I dare say, given what's happened to date, I suspect this will not be the last we hear about that.
Well, it's been going on literally forever now, so we'll just have to see what happens next.
If you fought it this much, I don't know why you wouldn't fight it anymore.
Okay, so I've got another case, but I want to talk about it in a slightly different way. This is about in the Fair Work Act, we have kind of 3 causes of action.
Excess of evil, we call.
Well, no. So it's under the Fair Work Act. So we've got unfair dismissal, general protections, and unlawful termination.
Right.
Well, now we never actually talk about unlawful termination because you can only get to unlawful termination if you don't have an unfair dismissal or general protections application available to you. And so it happens very rarely. And in fact, the entire time I've been working in employment law, there's only been one case that I can think of that I could genuinely start an unlawful termination application. So one was started.
Yes.
Yes.
So, and what was the reason that they said that the others were not available?
Well, there was a jurisdictional objection that there was a general protections matter available to them.
Right. So what were the facts?
I still don't believe this is still part of the story, even 2 years later. But somebody refused to wear a face mask.
Right.
Medical exemption.
And I take it they were terminated for that.
They were terminated. So the employee worked for a not-for-profit bookstore in Adelaide. And in accordance with the public health orders, the employer directed its employees to wear face masks unless they had a relevant medical exemption. Now, the devil's in the detail there. The employee claimed that to have a medical exemption based on the diagnosis of claustrophobia. And I'm sure that's a very serious thing. However, the employer did not accept this exemption, and when the employee continued to fail to wear a face mask, they terminated by no longer being able to fulfill the inherent duties of the job. If you can't wear a face mask at work, and there's a directive out there that you have to wear a face mask at work, you get fired.
Yeah.
And look, guys, they don't win. None of them win. I don't know. I mean, you might be able to present one that actually did win, but even the BHP redundancy cuts didn't win because they just got sent back to do
not win in the
not redundancy. The consultation case didn't win because all they did was got sent back to consult, and then everyone got fired again.
And they made it abundantly clear
we're gonna fire everyone.
that it was only the consulting that was the problem.
That was the problem. So look, they don't win, and this one didn't win either. But there was this whole argy-bargy about whether the full bench whether the commission had the jurisdiction to hear this type of jurisdictional objection, which was hilarious. Forever and ever, we've had, and it's changed recently. So general protection matters end up in the Federal Circuit and Family Court of Australia unless both parties agree in writing to arbitrate, stay within the commission. So that happens.
Wanting to keep it informal.
Yeah, it happens like once every 2 or 3 years. Most parties will only do it if neither party is represented.
Yeah, because you'll get a lot more assistance from the commission than you will from the judges.
Exactly. So it hardly ever happens. So there are, from time to time, jurisdictional objections that come up in a general protections matter. Most of them that I have seen that they've been a part of my practice are about whether the person should have filed a dismissal dispute over a non-dismissal dispute with the timeframes. And forever we've had correspondence from the commission saying they don't have they're not hearing those matters. Those jurisdictional objections must go to court.
Yep.
And then we had a recent decision that happened, I think, last year that said they do have jurisdiction to hear them, which would have helped me and my clients years ago. But
they in fact said that they must.
Yeah.
They must hear them.
Because they're the gatekeepers, essentially. So there was this question as to whether they could hear a jurisdictional objection based on unlawful termination. And it went around the mulberry bush a few times. And there was a lot of discussion about what was available and what wasn't available. And we've had this before in terms of whether an unlawful termination is available because one of the other ones isn't. And there was this weird argument that the union created about it being fine because it was discrimination based on what was it? Sorry, peoples. They had used discrimination, but in a really strange way because of the claustrophobia. It wasn't necessarily a impairment because
they're trying. Can I kind of take a bit of a punt and say that the jurisdictional objection was that the general protections
is available.
Discrimination 351
was available
because she could have argued
she had an impairment.
She had an impairment and therefore was being adversely treated because of that impairment. Is that kind of the counter? That's what
they were saying. But the union went, no, claustrophobia is not an impairment because it's not an illness or injury.
Very, very bizarre situation where an applicant is trying to get themselves out of a discrimination application.
Yes. So in the end, the full bench held that it was, in fact, a mental or physical disability.
Yeah.
And they could have, in fact. So they didn't get into the whole argument about the unlawful termination or the general protections. I just wanted to highlight that there was this really strange case out there that discussed whether or not the commission had the jurisdiction to do what they needed to do, which was deal with the jurisdictional objection itself, and the full bench said that they did, which I just wanted to let everyone know.
Well, it's a nice case because it reminds us of the things that we say to all of our clients all the time about it, which is the key word there is available.
Yeah.
It doesn't necessarily have to be that you're going to. It's not. It might be a worser option.
Yeah.
It might be worse for your case.
That's right.
And less.
Might be less strength in it, and so on and so forth. But you can't hide from the facts.
No, the legislation is clear that if the general protection one is available, it might be worse, but it was available. then you can't
Yeah.
do an unlawful termination.
Yeah. Now, the last one I want to talk about, just really briefly, I think this really just brings to mind how we need to draft things, employment contracts, is this poor sod had been working for a... Oh, I don't have it on here. It's kind of weird. This poor sod was working. He'd just come off, immigrated to Australia from a African country, and was told by his butchers that he needed to work 50 hours a week.
Cool. And so then in the contract, or was it the usual 38 plus reason?
No. It just said you'll be working 50 hours,
cool.
And it was an all-inclusive wage. The trouble was he was not given overtime. He didn't do anything, and so
the wage didn't.
So there was this. I mean, there was a massive problem. They weren't given the small business. So they weren't given the
Fair Work Information Sheet.
Fair Work Information Sheet. There was a bunch of issues about the pay slips. There was piles of problems with this, and the case is incredibly long. But and they were talking about whether he fell into one award over another. Right. But what I wanted to bring up today was just how important it is to, if you've got an inclusive pay rate, to make it absolutely known what you're including.
Yeah.
Because what happened in this case was they just said, oh, look, it's inclusive of X, but they didn't stipulate what it was. It wasn't in writing. The guy hadn't agreed to it, and they didn't mention it until 3 years after he started working. He just understood that he was going to get X amount of dollars for every hour he worked. And he wasn't even told that he didn't have to work 50 hours. And he had a new baby, there was a pilot, and he was working 7 days a week, 6 days a week.
Right.
And yeah, it just brought into sharp contrast. Focus. Yeah, just how much our contracts need to be clear.
Yeah, because it all comes down to what was agreed at the time, and if you don't make it clear, then...
Yeah, so everybody out there, if you are making all-inclusive rates in your employment contracts, again, there is another case, which they haven't decided on what the money is yet. Now that they've decided they've done a whole pile of things wrong, they have to go back and agree to what the money is, and then go back to court and see if the judge will agree. Yep. But look, I think it's super important that we get this right. You can't rely on what's happened in the past. You can't rely on what everybody else is doing. No. Get it right, guys, because you could be slammed like this guy's about to be.
And it'll be quite a lot of money.
It's super. It's all the penalties that are attached. There's a bunch of problems with this one. So yeah, just little hands up there.
As we say, I think we've said the last 3 podcasts, contracts are king.
Contracts are king. Get back to them, look at them, review them, make sure that what you are thinking exists in them.
Actually exists, yeah.
And the last thing, I want to give a shout out to Optimove. They're the ones that moved me from the city out to where we are in Tingalpa. They were brilliant, absolutely brilliant. So thanks a lot, Optimove. You were brilliant. Recommend them. They were great for me.
All right. Well, I think that concludes this week. Thank you very much, everyone. And we'll speak to you next week.
Yes. See you later, everyone.
See ya. Bye.